Happy Sunday if you're watching this live. We are going to be catching up on several things from this past week, and the first one's going to be Tracey Nix. She was the grandma who had two different babies, grandbabies, at two separate times, and they both died when she was supposed to be taking care of them. Sentencing happened. The parents got up and gave their victim impact statements, and it was horrible. So I'm going to skip that part of it because I already did that on my live. But I'm going to get to the sentencing and let's see what the judge has to say, because I just can't even imagine. And their daughter, the grandma's daughter, she went on about how much she loves her mom and wants her other kids to be able to see her and visit with her. And I'm like, I don't think I'm a strong enough person for that. I think that it happened twice and I would never give her the opportunity ever again. Just my opinion. All right, move myself to the corner. I already have it ready. And she's going to take the stand and do like her final statement to everybody, and then he'll go ahead and say, all right, here we go.
Okay, does she want to testify standing up or from the stand?
I'll go to the stand.
Thank you, ma'am. Please swear her in.
They do not have microphones in this courtroom. So if it's a little quiet, turn your volume all the way up. It was really bad on Friday.
Go ahead.
Please, Your Honor.
Yes.
Thank you. State your name, please.
Tracy Howard Nix.
And Ms. Nix, obviously, you are the defendant in this case. You have two children?
I do.
Okay. And their names?
Kayla Suzanne Nix and Rebecca Ann Nix.
Okay. Kayla is your firstborn child.
She is.
Okay. When you were pregnant with her, was that a difficult pregnancy?
It was difficult getting pregnant. It wasn't, the pregnancy itself was not difficult, but getting pregnant was very difficult.
And how did her birth make you feel?
How did what?
How did her birth make you feel?
I'm glad that you're sitting there, Kayla, because I want to speak directly to you. That's why I'm sitting here, facing you. Your dad and I didn't want to have children right up front. And, you have this thought that when you want to have children, that it'll just happen. And that's not what happened with you. I went through fertility. We tried on our own for a long time. And then I went through fertility drugs to try to have you. And then I went through surgery to clean everything out and to try to have you. And I tell you that because I want you to know how much you were wanted and how much you were loved. I thought you were the most beautiful girl that had ever been born on this planet. I thought you were the smartest girl that I had ever seen. And I adored you. Was I a perfect mom? No. No, I wasn't. But I love you. And I have always loved you with all my heart. And I tell you that because I can't imagine how I would have acted and reacted had you been taken from me. I cannot imagine that. And then if Rebecca had also been taken, it would have been more than I could have taken in. And that's the only way that I can understand what you've been going through and what Drew's been going through. I miscarried, but I didn't lose a baby like you've lost a baby. And I've tried very hard to understand where you've come from, where you are, and how I could be anything to you. I guess I answered that. What more?
Been on medication.
I think it's important to say that when they were giving their victim impact statements, the dad or her daughter who is married, it's that guy, and he said that she never once apologized and or even like broken down suffering like they were. She was very cold, and I just can't imagine someone doing that twice, and the remorse really wasn't there.
We're on medication for a long time, about 20 years. Do you have any idea if it was medication for 20 years?
No,
Okay, did you trust your medical provider?
I did.
Who all in your family went to this medical provider?
Rebecca did, and I think Kayla did. I believe Kayla did as well.
And when were you taken off this medication?
If you'll allow me, I need to back up just a little bit. May I?
Yes.
I know that both of you have felt that I have evaded questions. I haven't evaded questions. I wasn't allowed to talk to you. I wasn't given the opportunity to talk to you. And I think that the one piece, I mean, different ones have alluded to how things happen. But the piece that has been left out is I had Uriel 4 days the week before, and I wasn't expecting to have her on this particular day. Kayla called me and asked me, said she was getting her hair fixed, and asked me if I would be willing to take her. I would be willing to take that child any day of any week for as long as they needed me to. I love my grandchildren, and I would have done anything for them. So when she asked me to take her, you know, it disrupted what my head had in mind for that day. But I was glad to have her. So after I had a prayer group, a prayer time that morning, and I called Kayla and asked her, I said a few ladies wanted to get together and go to Beef O'Brady's. Does she mind? She had already asked me if I would keep Uriel, and I had said that I would. I said, do you mind if I take her with me? And she said no, that would be fine. So the piece that was left out is that when I went to the glass shop to pick her up, the other Kayla Nix, or Kayla Shock, helped me. I had Uriel in my arms, and she had the car seat. And I always put the babies on behind the passenger side so that I could see them out of my periphery. When your baby's sitting behind the passenger side, you always can just turn your head a small amount and see them. That particular day, there was a car that had pulled in close to the passenger side of my car. And when Kayla Shock took the car seat around to the passenger side to put it in, as I had asked her, the car was too close, and Kayla couldn't get the car seat in the car. So she came back around, and she put the car seat behind where I was sitting, behind the driver's seat. And we went on about our business. She was the talk of the town at Beef O'Brady's. We thoroughly enjoyed her. She was perfect. And when everything was over and I put her back in the car seat, I very succinctly and carefully had everything all packaged up, and I slid it on the floorboard under her car seat. And she was so sleepy, I think from just being on that whole time, that I gave her her bottle, and she immediately fell asleep. And I don't live far from Beef O'Brady's, but she was sound asleep within seconds of me backing up. So when I pulled in at the house, there were roofers. We were having our roof redone. And they had asked me to not pull into the garage because he didn't know if there'd be stray nails or whatever in the driveway or on the driveway. So I backed up under an oak tree, and I can remember literally looking over to the passenger side and the back. Nothing was there. I looked in the passenger side and the front. Nothing was there. I looked at the dash. Everything looked clean. And so I got out of the car, and I went in the house and began to do the things that I had on my mind to do. And this is perhaps where the medication does come in. She got quiet, and I forgot that she was there. She was quiet, and there was nothing there to remind me that she was in the car, except the things going through my head that I needed to do. So, may I go on from here, or do you want?
What else you want to say?
I didn't realize that Uriel was in the car. I literally forgot it for a long period of time. I did know that I had made plans with Aiden, which is my oldest grandson, to take him to Walmart in Sebring to look for some Christmas ideas for him. And then I was going to take him to dinner and have him back early because it was a school night. He was about 4:15 or so. He was feeding the pigs back behind the barn. And I got in the car and I pulled up to the barn. And Nay came with his lawnmower around so that my driver door and where he was sitting in the lawnmower, I just opened up my driver door and we could talk. And we were just chatting about I don't even know what. And I said, when did Kayla come for Uriel? And he just looked at me. He said, I've been outside, I don't know. And then I said, when did Kayla come for Uriel? And it began to dawn on me. And then I opened the door and realized that she was in there all along. I could tell that she had passed when I looked in the car. And I ran back behind the barn to the west side of the barn. I looked for anything I could find to hurt myself. I wanted to be gone. I did not want to have to deal. I didn't want to have to look at Kayla and Drew and tell them that this had happened. I wanted to be gone. But there was nothing there. And there was not any way that anything that I could find that would do that. So I fell on my face and I asked God just to take me. I said, I'm done. I'm done. I need you to just take me. And he wouldn't.
How do you feel about what happened?
I'm broken about what happened. I don't want to leave anyone with the thought that I'm making excuses, because I'm not. I was forthcoming with the detective. I asked to be taken to the sheriff's department. The video that you saw at the trial was during that time of me being in the sheriff's one of the interrogation rooms. When the detective came in, she asked me if I felt like giving a statement or talking about what happened. And without a lawyer, I told her everything I knew. I was not trying to hide anything. I didn't want to be there, and I didn't want to live at that moment, but I wasn't trying to hide anything. It ended up that I did go to Peace River, And I did it by choice, not because I was forced to do that. I didn't know what I was going to do to myself. I didn't get there until late or early morning, late night or early morning. And of course, there was no sleeping that night. And Kayla, you said that you had heard my voice. I don't even remember coming out of the bedroom or the room that I was in the next day. I'm sure that you're telling the truth on that. I just simply don't remember leaving the room. Usually that's a 72-hour hold. I stayed 2 weeks. And I stayed 2 weeks because I didn't know what else to do. I didn't know how I could possibly handle looking at Kayla and Drew ever again, or Joanne and Greg ever again, or Nay. You know, I love my grandbabies. Joanne and Greg love their grandbabies. Nay loves his grandbabies. And I just simply did not know what else to do but just go there and try to keep my head on my shoulders. So every day, the next day after I got there, I told you I got there late night, early morning, and so they had me go to bed, which was ridiculous. But the next day I saw the psychiatrist, and that is what I think it was Dr. Estevez described, that he immediately took me off of my medicines. He said that the medicine, that the Ambien, they had me on, just so you know, and I'm going to take a small step back. Drew, I don't know if you remember you coming into your house the day that I was sitting at your house. Kayla had asked me to come over, and I was sitting at your house, and I just was watching her at the house. And you came in maybe around 12:30 or 1 o'clock. And I got her settled, and I walked over to you, and I said, we haven't talked about Ezra. And I don't want to talk to you until you feel ready to talk. And when you feel ready to talk, please let me know. And I'll tell you anything you want to know. And then Kayla got up from her nap, and she came out. And I said the same thing to you. I said, I told Drew what I just said, and I don't know that you're ready to hear it yet.
Officer Hartman told me that they're running charges for Ezra that day. That's why he came home. That's why I went to my room. I told you that.
You were taking a nap that day because you had asked me to come by and just sit with her that day. And when you came out, I said to you, I spoke to Drew, and I told him that whenever you guys were ready to talk about Ezra, that I would do that. And I never heard back from either of you. So I wasn't avoiding talking with you. I was waiting on you to tell me you were ready to talk.
And that's why I'm gonna, and I understand.
Okay. And I've kind of lost where I was. That was the last thing I said before I went off on that. Can they read it back to me so that I know what the last thing?
This is a ECR, electronic recording. We don't have a live court report.
Okay.
You have to rely on what you discussed, or your lawyer can redirect you.
All right. I really do forget where I was.
Would you like to tell Kayla or Rashawn?
I think that you have the impression that I have not grieved and that I have not cared about your children. Drew, I particularly picked that up from you, and that could not be farther from the truth. After she was gone, I stayed in bed for what felt like weeks. I didn't eat. I didn't care if I ate. I didn't take care of my physical being. I didn't want to go outside. I would tell Nate over and over, I know that you want to fix something for dinner, but I just don't care. I just don't care. And I was like that a long time until finally I decided I had to do something about it. And the courts were good enough to allow me to go to Blackberry.
How long were you there?
Blackberry was a alcohol, drug, and trauma center, and I was there for trauma, and I was there 7 weeks. So I spent 2 weeks at Peace River and 7 weeks at Blackberry.
Did it help?
It did help because I saw a psychiatrist every day, a psychologist, or a therapist. I saw one of the two of them every day. My fear in just going straight into some sort of counseling was that if I ever opened that box and then didn't see somebody for another week, I would never have been able to handle that. But after 7 weeks of intensive attention and therapy, when I got home, I began therapy every Friday until actually the Friday before trial. So for almost 2 years, trying to wrap my head around it, trying to.
Has that helped you?
It has helped me.
So you're able to sit here today and at least somewhat talk about it without.
What I find is when I ask to talk about it, I can do that with my head now. But the second I begin to talk about Kayla or about Yuri or Ezra, I just, that's the trigger, and I just fall apart because I love them so much. And I want to just go on and make another comment that Drew said, that you hadn't even received an apology from me. You had not received an apology because I wasn't allowed to talk to you. I wasn't allowed to be close to you. But let me tell you something. I would give anything, including my life, if Uriel or Ezra or both of them could be here. And I mean that. I would give my life if they could be here. But that is not how God wanted that to be. And I can't explain it beyond that. But that's not how God wanted it to be. So I've got to figure out how to live. I've got to figure out how to not hurt myself. I woke up even just 2 weeks ago. Now, this has been 2 years and 4 months ago, and 3 years and 5 months, 3 months ago for Ezra. But I woke up 2 weeks ago out of a dead sleep in the middle of the night. And the first thing, I sat up, and the first thing on my mind was, what can I do to hurt myself? What can I do to get out of this? What can I do? And I thought of all these different ways that I could hurt myself or die. I wanted to die because I would never hurt your babies on purpose. You've got to know that. You've got to know that. I just would never hurt them on purpose. I loved your babies. With all of my heart, I love your babies. So if I have to apologize, if I have the opportunity to say I'm sorry is so menial and insignificant. But maybe if I told you that I would literally lay my life down for them, maybe that would make the I'm sorry more meaningful. I would do that if it would bring them back. You've got to know that. And I am desperately, desperately sorry for the pain that you've endured, for the loss, Joanne and Greg, of your grandbabies, for Nay. Nay has stepped up and he's done all the dirty work. He's done everything. And he's done it with grace and with strength. And he's not going to get to see his grandbabies either. I don't know what else to say. I could probably babble on But the important thing is that you know that I wouldn't hurt your babies. I just wouldn't. I think I did leave a part out when we were talking about the car and Caleb Shock put the car seat back behind my seat. I think I did say that though. That
And you couldn't see her.
and I couldn't see them. Yes, I did say that. Okay.
Not hear about Ezra. Hear about a year ago. You saw the court order indicating the finding was that you were asleep at the time Ezra passed and Nay had left. But you still feel guilty about it.
Oh yeah, yes, I do. As soon as there were toys in the floor. We're talking about Ezra. There were toys in the floor, all over the floor, and every toy this day and time makes a noise of some sort. And Ezra and I had a pattern. When he was at the house, I have a red chair, and I would sit in the red chair, and about, 10 o'clock or so, he'd climb up, and I would rock him to sleep, and he would take a nap. And this particular day, he climbed up in the seat without me. And Nay, when I walked in the room, Nay was standing behind him, and he was rocking the chair, because he never gets to do that. That's always my joy, to do that. And so Nay was standing behind him and rocking the chair, and he fell asleep in the chair. And instead of picking him up and putting him in my lap, I let him sleep there, because that was important to Nay, that he had put him to sleep. So I sat on the corner of the couch with only an end table in between us. We weren't 3 feet apart from one another. And I leaned my feet back, I laid the chair back, and I dozed off. I did. And he was asleep, and I was asleep. And Nay ended up leaving to go to Walmart. I woke up, I didn't go in a real deep sleep, but I don't know how Ezra made it through the living room without hitting a toy, because there were so many. And so when I opened my eyes, he wasn't in the chair. So I sprinted literally around the house, and I got in the car, and I went down the driveway, and I turned to the left and went to the stop sign, and I turned to the right and went down a small distance, knowing that his little legs wouldn't take him that far. And when I came back from going west, I cut across the pasture, because I saw something that looked like a little volleyball or something in the water. And I just cut straight across the pasture. I got out of the car before I even put on the brakes, and I scampered over. I hurried over to the pond, and I got him out, and I began doing CPR on him, and I screamed for the neighbor, and the neighbor called 911, and we were doing all that we could do. The only thing that we can figure is it was Christmas time, and we had white reindeer, and maybe he was enamored by the reindeer, and then the reindeer were probably 15 feet or so from the pond, and there were ducks in the pond, and that's the best that we can figure as to what brought him there.
And you don't know how he got out?
I don't know how he got out.
Okay. And you weren't aware he could open the door?
I was not aware he could open the door. He had started walking a few, handful of weeks before that, but I had never seen him reach for it's a lever handle, and I'd never seen him reach for the handle.
Yeah, I know we've discussed this at length in a prior hearing.
Yes, we have.
Okay. Anything else you'd like to say to the court, to the family?
Your Honor, whatever your decision is, I want you to know that I'm already in prison. No one can do more to themselves than I have done to myself. I wake up every day and I think about it. I go to bed every night and I think about it. And I will do that until I draw my last breath. So you may feel like you need to do something more, and I will understand that. But I do want you to know that I'm in my own prison, and it will last all of my life.
All right, state.
I just have one question, Your Honor. And I'm sorry, ma'am, I'm a bit confused. You had said many things. One of them was you don't want to make excuses, and then you listed off a bunch of things such as medication and cable shock putting the seat in the wrong spot. I just want to know from you, why isn't Yuri here with us today?
First of all, I'm not making excuses. Those were factual events. And Yuri is not here because I left her in the car.
No further questions, Your Honor.
All right, anything, may she sit down, defense?
Yes, Your Honor.
Thank you, Ms. Nix. Defense, more questions? All right. Defense, make your argument once your client gets to your table after you confer with her briefly, please.
Your Honor, where would you like me?
Wherever you like. You can use the podium, either one. It's up to
Thank you, Your Honor. I think everybody here has figured out there's no winners here. Everybody involved in this case, Tracey, May, Drew, and Kayla Shock, suffered tremendous losses. Brings tears to the lawyers, brings tears to the people here. Uriel's family has gone through living hell, apparently for several years. I understand that these people love their child. Pretty obvious. It's a parent's worst nightmare, Judge. I don't know if your Honor has kids, but if you do, I'm sure it would be your worst nightmare.
Got 2 kids and 2 grandchildren, 1 and 3.
I didn't want to get personal with the court.
It's fine, it's well-known, documented knowledge.
Yes, sir. It was my worst nightmare. But my child was young. His family also includes Nay and Tracey Nix. Whether you lose a child or whether you lose a grandchild, pain's horrible. It's horrible for everybody in this case. I don't know how they've handled it, Judge. I don't know how any of them have been handled. I've seen anger and rage by the Shocks, not so much today, just the pain that they've suffered. There's some things that were stated in the PSI and a letter by Kayla that I was going to point out, but I'm not going to do that. I think it's insignificant now.
And for the record, I reviewed all the letters. I've reviewed your motion for mitigation. I reviewed all the PSI documents well ahead of time.
And I do want to say one thing. There wasn't any car seat, whatever you call that, the reminder in the back of the Lexus. I don't think Tracey has lied to anybody about this. I think she's been completely honest, forthcoming. That's certainly a reason to mitigate. Although we know where we are, we're sitting there at 44 points, which allows you to give anything from probation up to 5 years. I do want to go on something that the court will allow me to. I'm not here about Ezra. I did hear
both of the parents talk about Ezra. And they should talk about Ezra, because I'm sure they don't want him forgotten. But I guess also for the media, Judge, a couple things I'd like to read, if you please, Your Honor.
Okay.
From the order granting defendant's motion in limine excluding certain evidence. This was fully fleshed out. The state presented all the evidence that they had regarding the death of Ezra. The defense presented their testimony. Just a couple things here, Judge. Findings of fact in that case. Neither defendant nor Ezra's mother believed Ezra capable of opening doors at the home. Defendant's husband had seen Ezra unsuccessfully try to open double doors at the home on one occasion. The death of Ezra Shock, while a tragedy, was the result of simple negligence, not rising to the level of culpable or gross negligence. The alleged acts of negligence were being unaware the child had the ability to escape the home and failing to properly supervise him. There's insufficient evidence to conclude that defendant was awake when her husband left. Therefore, defendant cannot be the person who is responsible for the act of negligence. So I know these, and I understand that Tracey and they were both there. Tracey's caught pretty much of the blame from the family, but again, when you look at all the evidence, the proof, then I think it shows that she wasn't responsible. And if it please Your Honor, indulge me. Your order also states, here the state merely suspects that defendant was awake when her husband left, making her the person responsible for the care of Ezra and thus the person who committed the alleged collateral act. This is despite testimonial evidence from her husband to the contrary, that she was asleep and he tiptoed out. This is consistent with video from Detective Ward's body-worn camera taken immediately after the incident, where defendant, who is still under the emotional influence of the incident, says she was asleep when her husband left, State's Exhibit 9. Defendant's subsequent interview with Detective Hart on December 30th apparently was not recorded and is confusing as to when she says she fell asleep. The confusion continues within the affidavit complaint filed by Detective Hart, which states Tracey said that Ezra had fallen asleep in a chair. Her husband, Nunn Nix, left to run errands. When she woke up, Ezra was missing. May Nix's proffered testimony reveals he decided to go shopping and discuss it with the defendant. After both Ezra and the defendant fell asleep, he recalled tiptoeing out of the room. Later, he received a call from the defendant asking him if he had taken Ezra, and when he answered no, she immediately hung up the call. He also recalled he had previously seen Ezra try and fail to open a door in the home. Now, I say this and appreciate the court allowing me to bring this up again. We're not here about that, but I want the family of this young victim to realize that when you look at the evidence, Tracey was not at fault. And I want the media to know this also. The court, you said you'd seen the letters. I'd underlined some things. I might incur the court's wrath if I repeated that. There were a lot of letters in support. Obviously, the court knows she's a good person. She did a lot in this community for over 40 years. She served this community both as a teacher and as a principal, and as a Sunday school teacher and an active member of her church. Obviously, the court knows she has no prior criminal record. The jury had found there was no culpable negligence here. Your Honor, in previous ruling, found that count 2 is strict liability. I never even argued count 2 in closing argument. There was nothing to argue. Obviously, we disagree, and reasonable people can disagree with respect to count two and whether there needs to be any type of intent there, but we'll save that for another day. I'll also say that Tracey is a wonderful person. This tragedy occurred, and we're not blaming anybody except when you're on medication, a medication like that, and we presented from a very, I say, renowned expert concerning the medication that she was on for a number of years was totally inappropriate. The Ambien was more than twice the dosage she should have been on, combined with the other medications. I'm surprised she did as well as she did on this medication. Again, she and the whole family, both Tracey Nix and the family, has suffered tremendously. She's always going to be haunted. The thought of suicide, and I can understand that, and I know you have grandkids, I have grandkids. Doing something to them would be not only doing it to them, but doing it to your child too. I don't know how Tracey has been able to live with this other than the constant counseling that she's had. I'm going to ask the court to be fair, ask the court to use wisdom. This is very emotional. When the lawyer gets tears in his eyes, you know it's an emotional case. You're sitting at 44 points. I'm asking the court to look at all the facts, look at what Dr. Estevez said about the 5 reasons for punishment, and I'm going to ask the court to give her some jail time, some county jail time. If you think she needs probation, put her on probation for whatever terms and conditions that you think appropriate. I know she's going to want to see her grandkids who her parents will allow her to see. And as Tracey said, we're leaving it in your hands, and I'll trust that you'll be fair.
All right, thank you. All right, Ms. Nix, rise and come to the podium. You can come over with your attorney here. I sat in this trial. I picked up this case. I started down here July 1. I picked up this case. And I did the motion for motion in limine. And I know exactly what I wrote and what I ruled. You can't use other crimes or acts to show bad character or propensity. It has to be clear and convincing. But it doesn't negate the fact, just because I didn't use that event, it occurred. And it was with 2 people there. It was with Mr. Nix and Mrs. Nix. And when I hear today situations and testimony about where the seat was put in the driver's side because Kaylee Nix did it, not Mrs. Nix, Miss Tracey Nix, the defendant, did it, that's inconsistent with the deposition testimony that Kaylee Nix said, and it's also inconsistent with what she wrote in her victim impact statement. Then I listened to her testimony about the bureau was sleepy and gave a bottle and immediately fell asleep. And there's a video, and I don't recall seeing that. But I also recall in the trial, they talked about giving the baby a straw and some water in a straw, and that this was a situation where their baby didn't have food and milk. And I went through, and I'm going to come down to this in a minute, but the evidence that comes in, I wasn't there, you weren't there. The only people that were there were Miss Nix, and at the time, we get evidence after the fact, and when we're sitting in the room and we're watching it, it comes in. Like, here's the back seat of the car, evidence 41 that came in. Here's the front seat of the vehicle, 40, where there's wipes and things in a car. And when people go places with kids, they leave objects, thread on the steering wheel, things in the front seat to remind them where they had a child. And I'm not talking about a child that was there, you had an hour-long, 2-hour-long drive. I'm talking a 7 to 9 minute drive. Here's the exhibit 29. It's the back seat of the car. There's evidence everywhere. Then we see the picture of when Nay and them got there. That's evidence 23. I then have a half-empty thing, a bottle, evidence 35. So I see all of that, and I see all the reminders. And then I remember Kaylee Nix saying that the Lexus, the red Lexus, was equipped with a red rear occupant alert to alert an adult to a child in the back seat. And I know that these cars, Fords, Lexuses, everything has so much weight in the back seat, beep beeps go off. And I hear her saying I didn't have that. But then I read the deposition taken of Kaylee Nix, docket entry 201, October 1, 24. Do you know who put the car seat, page 32, line 5 to 7? Do you know who put the car seat into the car that day she picked Uriel up at the glass shop? I do not. I do know it was her tendency to put the car seat in herself. Okay, Kaylee, answer. She typically, whether I was standing there or not, would pick her up and set her in there. And then I would typically help reach over and strap her in. But a car has sensors, weight sensors. So that, just like my vehicle, whenever I stop and put it in park and turn it off, there's a loud ding that says, check your back seat if there's weight in the seat. And so those are things that I'm aware of that were in a vehicle. So when she put her in there, I did not imagine that I had any other staff assist her in the moment putting her car seat. Did she normally put the car seat behind the passenger or driver's seat? I have her telling me it was in the driver's seat because Kaylee did it, and I have Kaylee saying that it was typically in the driver's seat. And then I have these tendencies and these things that I see that show that there's a baby in the car. And let's not forget that we just left Beefville Brady's. This child was the apple of everyone's eye there. I've been to the Beefville Brady's. I've had lunch there. There's a lengthy video. There's a video of the car in the parking lot. At the end of the day, Kaylee Shock presented this evidence to me through her testimony, her victim impact statement, and her the deposition. The defense has presented to me the witnesses and the evidence. What I know for a fact is Tracey Nix left Euro in the car at 2 p.m. for over 3 hours. At no time during the 10,800 seconds that elapsed did she think 1 second about her granddaughter. Uriel Shock was there for 2.5 hours with her that day, and she just saw her 7 to 9 minutes before, and then she goes to the residence 7 to 9 minutes away. This child, like I said earlier, was the apple of everybody's eye. It captivated, entertained the patrons and the people at Beef O'Brady's, much like a 7-month-old does, a year-old does, a 2-year-old, a 3-year-old does. You know what you're doing with them, and in 7 to 9 minutes, by golly, you know where that child is. And anything to the contrary, and any excuse to the contrary, is just that. I heard and saw the body cam footage along with the interrogation room video of Tracey Nix immediately discovering what happened after she has a grandchild passed away. She was distraught. I don't believe there's a lot of remorse in that about her grandchild's suffering and death. Rather, I see her more concerned with her community image and the death of the child. I want to leave. I want to go away. I want to do this. I want to do this. I want to do this. And I hear today the evidence and the testimony, and I get a little more remorse on that, but is it truly remorse?
Yes.
Tracey Nix, throughout these proceedings, has contended these acts are involuntary. She couldn't form the requisite intent to commit a crime. Her narrative is that she forgot because of senility or by taking her prescribed mind-altering medications. There's no credible evidence to the court that's persuaded this court to mitigate her sentence as the attorneys have requested. This defendant, like many other defendants facing prison sanctions before, is trying to avoid or lessen a prison sentence once arrested and after a jury finds them guilty. They justify what happened rather than accepting blame and truly evidencing remorse. I have practiced law for 30 years. I've sat on this bench for over 3.5 years. I've met my share of people in the Florida state prison system, the federal system, and I understand that they minimize their conduct and they also don't accept responsibility. And that's how it is. And there's a pile of them down at Hardy Correctional that'll tell you the same stories that I heard here today. The ultimate determination of when we do a case, and I excluded the evidence of the experts on the defense side. It's when you look at whether a defendant is competent to proceed, it's my determination in state court, in a trial court. Under the Dougherty v. State case, 149 Southern 3rd, 672 at 678, the trial court is not bound by the reports or opinion of experts. The defense in this case never afforded nor volunteered Tracey Nix to the state of Florida to have her evaluated by its own experts, so the state of Florida, the citizens of Florida, were denied the right to contest the evaluation and procedures and conclusions of the Tracey Nix retained, hired experts. They all say we're here for our time. They come in here, they get paid, they give their opinion. They give their opinion. If it's valid for the defense, they testify. If it's not valid for the defense, they don't testify. I heard this man's testimony. In a competency or an insanity case, the state has the right to contest the evaluation procedures and conclusions of the court-appointed experts. Had she alleged incompetency or not guilty by reason of insanity, the state of Florida and all the citizens would have the ability, the state would have had the ability to hire its own experts to evaluate her mental and physical claims. The state was not afforded that here. And that's why we have a 35-year-old law that says you can't bring in diminished capacity. I ruled on that. I'm not going to revisit that ruling. The state, as a representative body for the citizens of Florida, has a right to a fair determination and meaningful opportunity to be heard to conduct its own review of Tracey Nix. All of her defense experts were hired for their time and to defend her. They had unbridled access to her so they could present their opinions to the court. What I noticed was there was no, what did the MRI findings say? I don't know. I wasn't given that. There are many tests that mental health experts can perform and routinely do perform on criminal defendants to determine if a criminal defendant is falsifying or exaggerating facts or symptoms. There's called malingering. There's no medical records nor testimony presented to this court that she suffers from Alzheimer's, dementia, or senility November 1 of 2022. None of the defense experts have testified they tested Tracey Nix for malingering or confabulation. They simply say, trust us, we are experts. The court declines to do that. In Florida, the term for imprisonment for a second-degree felony is up to 15 years in prison. First degree is up to 30 years. Life is up to a defendant's life. And in a capital case, I can sentence somebody to death if the aggravating factors exceed the mitigating factors. In this case, Tracey Nix has been found guilty of a third-degree felony, punishable by a maximum of 5 years in Florida State Prison. On January 15, 2025, a jury found the defendant guilty of one count of leaving a child in a motor vehicle in excess of 15 minutes causing great bodily harm, but in reality causing death, and not guilty of one count of aggravated manslaughter. I've already gone over what I talked about with the Rule 3.704D9 about the victim injury points. Her score sheet is 44 points. Under Florida law, the maximum sentence I can impose for Tracey Nix is 60 months or 5 years in Florida State Prison. For me, as a trial court, to impose a departure sentence, it's a two-step process under Banks v. State. 732 Southern 2nd 1065 1067. First, I must determine whether I can depart. That is, whether a legal basis exists for the departure sentence that has been established by a preponderance of the evidence. 2, even if a valid and supported legal ground exists to permit a departure sentence, the trial court must still determine whether it should depart and whether a departure sentence is the best sentencing option in a given case. 2 facts the defense argued in their motion to mitigate. 9, that Tracey cooperated with the state of Florida to resolve the offenses she was charged with on November 1, 2022. The court finds that not to be the case here. Tracey Nix did not cooperate. There's no competent substantial evidence that the crime she was charged with was resolved as a result of her cooperation. To the contrary, she investigated it, she went to trial, she didn't enter a plea to count 2, and she didn't cooperate with law enforcement or the state prosecutor. The second ground they sought mitigation is 10, which is an unsophisticated, isolated incident. There's 3 elements that must be proven by the defendant when you raise that mitigation, not 1 or 2. Number 1, Tracey Nix has to prove the court that the offense was committed in an unsophisticated manner. Number 2, it was an isolated incident, and she has shown remorse. All 3 elements have to be proved. You can't prove 1 or 2, all 3. Tracey Nix and her husband had the 17-month Ezra at their home, who died 11 months earlier. That is a fact. That came in every hearing I've been in, and I've heard it today as well. The grandchild Uriel Shock's tragedy is not an isolated incident. This is the second. The court watched and heard her interview. I do not believe she's showing remorse. I believe she's showing sorrow. It is impossible for a defendant who refuses to accept responsibility for an offense to show remorse for that offense. Sympathy is not the same as remorse. Sorrow is not the same as remorse. What I look at in the Florida statutes when I deal with sentencing under 921.02, subsection 1B, the Criminal Punishment Code's primary purpose is to punish an offender. Rehabilitation is subordinate to the goal of punishment. Subsection C, penalty imposed shall be commensurate with the severity of the primary offense and the circumstances surrounding the primary offense. The court does not find that the defendant's sentencing proposal is the best sentencing option. Rather, Tracey Nix should spend the next 60 months in Florida State Prison with credit for time served. The trial court is guided by the code, the sentencing guidelines, and the express purpose for criminal sanctions under Florida law, and a Florida State prison sentence of 60 minutes is the best sentencing option. The court also finds that she knew how she was feeling on November 1. The multiple videos, some with audios that day, and the testimony of her Bible study and many friends unequivocally established her awareness that day she is not competent, nor is she insane. She caused aerial shock to suffer an agonizing, prolonged death that was avoidable. The court saw all the evidence in the photos. I want to note the diaper bag that was brought into evidence, Exhibit 36, Exhibit 37, Exhibit 38, Exhibit 39, was the most organized diaper bag I've ever seen in my life. And I heard testimony that the child didn't have food, this, that, and the other thing in the beef O'Brady's, and they fed her through a straw. I note that it was an excellent diaper bag. The bottles, food, medicine, and the items were all in quart bags, Ziploc bags. For witnesses to say or allude that Uriel had no milk, formula, or food is hypocritical and untrue. The court finds such testimony by any such witnesses not credible for sentencing purposes. The defense's recitation of their mitigating factors without confirmation by any unbiased expert, in addition to the deficiencies the court found earlier, also fails to establish by a preponderance of the evidence any mitigation that is to be considered by the court today, nor do they amount to competent, substantial evidence for this or any court to justify a sentence of less than 5 years in Florida State prison. The defendant restrained Uriel Shock in a car seat, and the child was severely injured before she died. There were plenty of signs to Tracey Nix that she had a baby in her car that day and she was responsible to protect it. She failed in her protection of Uriel. I will not fail this state or this community in my duties as a judge to fashion a sentence that I feel is appropriate for these type of charges. You can call it whichever one of the 5 points you call it, but I'm calling it a just and determinate sentence based upon the facts and evidence that I have seen here and heard here and presented today. The court hereby sentences Tracey Nix to Florida State Prison for a term of 5 years of Florida or 60 months with credit for all time served. A $5,000 fine shall be reduced to a judgment lien. The cost of prosecution and restitution will be reserved for 60 days. Y'all can agree on it or we'll have another hearing. She will be remanded under the supervision of the Department of Correction until her term of prison ends. Now I'm going to speak to this community. I'm not from here. I'm from Winter Haven, Polk County. This community needs to move past this case and leave Kayla and Drew Shock alone. Let them and their 2 children live in peace. This family has lost 2 children, Ezra Shock and Uriel Shock. The tragedy of this case is undeniable. A baby's life is over way too soon, and a family has been severely impacted in unimaginable ways. Whenever a child dies, this entire community suffers. This community needs to move forward and start the healing process. I have made a final and determination here. I'm not putting people on probation to be walking around this community to rehash an issue or something to come up. I have sentenced her to 5 years in Florida State Prison. I want this community to move forward. The legislature defined this felony crime. A fair and impartial jury found Tracey Nix guilty, and I, as a circuit judge for Hardy County, have sentenced her accordingly. Ms. Nix, you have 30 days to appeal the judgment and conviction of this court. If you cannot afford an attorney, one can be appointed for you without cost for appellate purposes. Mr. The state, do you have anything further I need to deal with?
Your Honor, to head off an issue, we'll waive cost of prosecution, so we don't have to have here.
Okay. Do you want to reserve on restitution? If you don't, you can reserve it, and then you can either agree, disagree, or say, Judge, we're not having it, it'll go away on its own.
Your Honor, we can reserve it, and it'll probably go away on its own.
Okay. Mr. Fletcher, anything further we need to go on?
One thing I have to say as her attorney, May Nix Day, and I think, I don't know if she's still here, Alex Amanda Fletcher, who testified there wasn't any car.
I understand. I understand.
Okay, because you said that, I thought you said there was.
You're talking about the car seat?
Obviously, we disagree about the remorse. I'm not gonna argue with that. We also have a motion for supersedious bond.
You're absolutely correct. Once you file your notice of appeal, the supersedious bond statute will go into effect. You'll then have a hearing on your motion. But the first event that has to happen is the notice of appeal. Once that's happened, send it to my JA For your information, Ursula Nathy is my current JA. Next week, my new JA will be Julie Cochran. Her email address will be circulated on the website. It'll be J. Cochran. So file your notice of appeal. You can either reiterate the motion you've already done on supersedious bond or file a new one, and then I'll set a hearing time that's commensurate with both of y'all's calendars. Mr. Coleman and my JA will work with you on that, okay? And if you're not going to handle the appeal and you got a public defender, please get your paperwork in sooner rather than later.
We have an attorney.
Thank you. Court's adjourned.
All right.
And I'm adjudicating her guilty, okay?
Wow, that was a lot. I was surprised that the max was 5 years. I understand the why and how it got there. But sometimes I feel like, at least in this case, since there were 2 babies, that maybe like Ezra's should have been added on for 5. So maybe like 5 for the newest one and 5 for the other one, total of 10 years. But I guess, getting the max is a win if that's what we're going to call it. Although I don't know if you were hearing, but they're going to appeal it. And I'm like, wouldn't you, if you were this devastated and, you're a mom and grandma and you're like ruined from all of this, why would you appeal it? Just wait until you can have bond and then get out. I don't know. To me, it's just she's just trying to wipe away anything. She's not sitting here saying, oh my gosh, I'm so bad. She finally said I'm sorry once. But yeah, I think you did a good job. All right. I'm going to be on, let's see. I'm going to be on in just a short while. I have a new video for Lori Vallow. She did an interview that I'm going to have us all watch because tomorrow her trial starts. So we will be watching that tomorrow too. All right, if you've been on live with me, thank you for watching, and I will see you later this evening.